Well, back now to our top story. Dramatic testimony from a current Department of Justice attorney. After 12 months, almost, of being ordered to ignore subpoenas, longtime DOJ attorney Christopher Coates today defied orders from his boss and made some powerful and stunning allegations, offering evidence and a first-hand account that race and politics are driving decisions at the Department of Justice about which laws get enforced and which do not. Here is just a sampling of some of the back and forth between Attorney Coates and the commissioners.
In the reluctance to enforce race-neutral laws against minorities, is it your opinion that we're talking about Afro-Americans, or are we saying that Hispanics, Native Americans, Asians, that you would feel that there would be a reluctance to move forward even on those cases?
I think that that the philosophy that some people have, that the Voting Rights Act was intended to benefit people of color, and that, that therefore the federal government should not be involved in enforcing the provisions against those minority groups.
Well, Ashley L. Taylor Jr. and Michael Yaki are commissioners on the U.S. Commission on Civil Rights. That is the group that is looking into these allegations and has been for many, many months now. Gentlemen, thank you both so much for being here. I know politically you come from ideological different ends of the spectrum and have come at this inquiry a little bit different, so we're glad you're both here to represent both sides. Ashley, let me start with you. Mr. Coates basically giving credence to the testimony you all received from J. Christian Adams, the first DOJ whistleblower to come forward with similar allegations. This case is now about much more than the dismissal of the new Black Panther Party case. It is about an alleged policy at the DOJ of not enforcing the voting rights laws where the victims of the voting rights intimidation or other misdeeds are white. Could you just sort of frame up where we are right now with this investigation and what could potentially happen here to the Department of Justice?
Well, thank you, Megan. And what we have now is a situation where we have our second witness to come forward. The first witness was forced to actually quit his job as a trial attorney with the Department of Justice. This second witness felt compelled to invoke the Whistleblower Protection in order to testify about a struggle, a philosophical struggle occurring within the Civil Rights Division. You have some people within the division, according to his testimony today and according to Adams' testimony earlier, that fundamentally believe the law does not apply equally and that the laws, particularly the voting rights laws, were not intended to protect certain people. In other words, they look first to the victim and the perpetrator to determine whether or not the law should be applied equally. And he said as he rose through the ranks, he started in 1996, eventually in 2008 becoming chief of the voting rights section, he found that policy strained his relationship with his political superiors, so much so that they criticized him when he would ask potential trial attorneys during the job interview whether or not they would be willing to enforce the law equally. That's a strange question to ask for someone who's interviewing for a civil rights position, but he felt he was compelled to ask that question to ensure that they were attracting people who would indeed apply the law equally. What's more disturbing, Megan, is that he was told to stop asking that question by a political appointee. To
Loretta
stop
King.
asking.
Loretta King, whose picture we have.
That was some of the most shocking testimony we heard today, that they would deem it to be inappropriate to ask a potential hire whether or not they would apply the law equally.
You know, Michael Yaki, give me your take on it, because I know many who are, more on the left-leaning side of the commission have dismissed the controversy over the new Black Panther case as not that big a deal, and we don't need to go over that necessarily right now, but what is your reaction to these broader brush allegations now that J. Christian Adams and Christopher Coates have made?
Well, I think there's a difference here between what they say and what the facts really demonstrate. The facts is that the Obama administration has enforced the law in a race-neutral fashion. They recently intervened in the case in Noxubee that was brought by the Bush administration, have continued that case to protect white voters. But I think what we really have here is simply the ideological remnants of the politically polarized and ideologically rigid Bush administration. There was an OIG
report. But Chris Coates, let me just jump in and then I'll let you continue. But Chris Coates worked for both Democratic and Republican administrations and used to head up the ACLU's voting rights section. I mean, this guy, he's no dyed-in-the-wool conservative.
But in testimony here today, he actually defended the fact that maybe his ideology wasn't quite all that people tried to make it out to be because of his ACLU background. The fact of the matter is that he said today in testimony that he was friends with Brad Schlotzman and Hans von Spakovsky, the two people who basically politicized the Justice Department as found by the Inspector General and by the Office of Personnel Management at Justice. So the fact is, he and Christian Adams are part of the group that lost the election. They're mad about it. They're making these wild accusations. And the fact of the matter is that Adams came to us and said he would bet that Justice wouldn't intervene in Noxubee, and they did. They went above and beyond to protect white voters.
How about that, Ashley Taylor, that Mr. Yockey's allegation that they did, in one case, intervene to protect white voters?
Well, let's all recall how this investigation began. It began because the Bush administration filed charges against the new Black Panther Party for their conduct in Philadelphia in front of a polling booth. The judge entered a default order. When the new administration came in, they simply walked away from the case. So we ask a basic question: why did you walk away from the case? The testimony we heard today and the testimony we heard from Mr. Adams earlier both demonstrated that the factual basis that they provided by way of an explanation simply doesn't make sense. What makes sense is what they describe as a philosophical struggle within the division as to whether or not the laws should be applied equally.
Mr. Yockey, let me ask you this. Let me ask you this. Let me ask you this, Mr. Yockey.
Yes.
I understand you dismiss both men's testimony because you think they're conservative ideologues, essentially. I'm paraphrasing. What if they're right? What if you're not right to dismiss their testimony? What if Julie Fernandez did sit down and tell the Department of Justice attorneys at several luncheons not to bother enforcing the voting rights laws where the victims are white? I mean, doesn't that warrant at least getting Fernandez in front of the commission, getting this Loretta King in front of the commission? What if this is really happening?
Well, I think what's more important is that in testimony today by Mr. Coates, he talked about how Justice during the Bush administration walked away from protecting black voters in Mississippi.
That's also important, Mr. Yockey. That is important. I agree with you. But right now we're in 2010, and we're about to go into a midterm election and a presidential election. I'm asking you, rather than just dismissing the under oath sworn testimony of two Department of Justice attorneys, I'm asking you, sir, what if it's true? What are you doing about it? Why not get Julie Fernandez, Loretta King, these other DOJ attorneys who have been specifically named by these lawyers as issuing these mandates before your commission and ask them some hard questions?
Well, there are two reasons. One, I believe that actions speak louder than words, and the administration's actions in Noxubee in July of this year
in that one case.
Well, it is the only one case that is out there. The fact is that people like Hans and Chris and other people want us to sue in all these other cases when, frankly, there's nothing at risk for voters but to waste judicial resources. The fact of the matter is that you have a Justice Department committed to equal protection under the law. They show that they're doing that in Noxubee. I'm sure they're going to show it in other actions.
Okay.
What one person may have heard someone say is always going to be he said, she said situation.
It's two lawyers now who claim they were there, and they claim that there was a room full of people. I've got to go, but Mr. Taylor, I'll give you the final word.
Well, the facts do speak for themselves, and in this case, we have a whistleblower who slowly had his rights and responsibilities within the division taken from him, compelling him to move to South Carolina because of the strained relationship, because he wanted to enforce the law equally. Those would be the facts, I think, that as a commission we have a responsibility to bring out, not to make accusations, but to get the facts out. And Megan, as you've said, ask the people who have been identified by these two whistleblowers to come forward and share with us what's really going on.
Yeah, Julie Fernandez and Loretta King in particular, and Eric Holder would be another person to speak directly to this if he would make himself available to the commission or to the reporters covering this. Listen, gentlemen, I appreciate you both coming on. This is a case that's gotten a lot of attention, and I appreciate both of your perspectives. All the best.
Thank you.